Hi there and welcome to ET Now. I'm Ashwin Mohan and you've tuned into IBC Litmus test, which is part of our continuing coverage of that crucial order which came in earlier today from the NCLAT, the National Company Law Appellate Tribunal, in the high-profile case of Essar Steel. Now, that case has seen lots of ups and downs, and the verdict today has held that the bid submitted by Numetal in round 2 of the race of Essar Steel is valid. And as far as the fate of Arcelor Mittal is concerned, what the NCLAT has held is that Arcelor Mittal will have to submit dues relating to two of its earlier companies, namely Uttam Galva and KSS Petron, and that amounts to around 7,000 crore rupees, so almost $1 billion. So Arcelor Mittal has to pay dues if it has to make itself eligible, and for that it has been given 3 days' time. So that in a nutshell is what came in from the NCLAT today, and this case is a test case because this case and its outcome will determine the entire bidding methodology, the nature of bidders, under what circumstances are bidders eligible, under what circumstances are bidders ineligible. And therefore, to dissect the key takeaways of this order from the NCLAT today, we have with us a power-packed panel. 4 top corporate lawyers, all of them who are keenly tracking the IBC. We're joined by Shardul Shroff, Executive Chairman of Shardul Amarchand Mangaldas, Nilang Desai, Partner at AZB and Partners. We have Krishnava Dutt, Managing Partner at Argus Partners, and we also have Mr. Alok Dhir, Managing Partner at Dhir & Dhir Associates. Gentlemen, all of you, thank you so much for taking out time and joining us on this special show. Mr. Shroff, let me kickstart the discussion with you. What is it about the facts and circumstances of the race for Essar Steel that makes it such a test case? Because there are foreign investors looking very keenly at the outcome of this case because they expect that the case will set a precedent. The verdict which will come in will set a precedent. And why do you think this case is so important for the current IBC regime?
I think the interpretation of Section 29A, as has sharply arisen in the case of Essar Steel, is perhaps the unique feature of this matter. Both Numetal and Arcelor Mittal had to undergo the test of Section 29A, and whilst the first round bid of Numetal was considered to be ineligible on the ground that Revant Ruia, the son of Ravi Ruia, was connected with and a connected person and was ineligible because he was the son of Ravi Ruia, who was the promoter and person in control of Essar Steel, was disqualified. In the second round, they have held that by virtue of the exit of Aurora Enterprises Limited, which was controlled by Revant Ruia, and their substitution by Jindal Saw or JSW, that cures any infirmity of the first bid. Whereas in relation to Arcelor Mittal, the principle that they have applied is that they need to cure the defaults of Uttam Galva and of KSS Petron before they become eligible to bid or eligible to that their bids be considered. So this is perhaps the first time the principles of Section 29A and the circumstances of its applicability has been adjudicated by the appellate tribunal, and therefore its importance.
Thank you so much for your preliminary comments. Section 29A, of course, has been the most controversial section of the IBC, and this is a section which bars defaulting promoters from bidding for IBC assets. Let's take this conversation forward and get in Mr. Alok Dhir. Mr. Dhir, the eligibility hurdle as far as Numetal is concerned seems to have been cleared because the NCLAT has held that their bid in round 2 is valid. Would you say then that currently as we speak, Numetal has an edge as far as the race for Essar Steel is concerned, because they've already voluntarily disclosed their bid in round 2 and that stands at a whopping 37,000 crore rupees?
No, I wouldn't say whether they are, they're certainly the leaders, there's certainly the clarity has come with respect to Numetal that they are eligible. In fact, when the second plan was submitted on about 29th of March 18, it was held that Aurora Enterprises has no shareholding. There are only 3 shareholders: Crimnium Bay, International and TPE, and therefore they are eligible. They have a very substantial bid, and that's a bid which has been disclosed. Insofar as Arcelor Mittal is concerned, they will be eligible and their bid can be considered provided they deposit 7,000 crores which is lying in the escrow account with up-to-date interest, and they have 3 days period to do this. And in case Arcelor is not able to deposit this money or transfer this money from escrow account to the payout to the lenders, then they will be treated as ineligible. So certainly Numetal has an edge today.
Numetal clearly has an edge as we speak, but let's not forget that this is a verdict from the NCLAT and can be appealed at the Supreme Court. Krishnava Dutt, why don't you join the conversation as well? You heard Mr. Alok Dhir speaking about the shareholding structure of Numetal. Do you perhaps think that the replacement of the Revant Roya-led firm by JSW Steel in round 2, do you think that rejig in the structure and the voluntary disclosure by Numetal that if required we are ready to rejig a structure to meet the IBC norms, do you think the flexibility of Numetal, the upfront flexibility of Numetal when it came to presenting their structure before the committee of creditors, do you think that proved perhaps crucial in the long run?
Oh yes, it does. I think in terms of disclosures, Numetals had made the disclosures in terms of the holding structure. Even on the 29th March, I think as just Alok said, was the structure had changed completely and the SRs did not hold it. And after that they came and effectively disclosed the structure with the tie-up of JSW. Yes, it does make it.
Sir, AZB and partners, would you say that the verdict today is a setback of sorts for Arcelor Mittal? Because clearly Arcelor Mittal was of the opinion that mere selling of shares in Uttam Galwa as well as KSS Petron would be sufficient and would not require any further commitments from their end. But clearly today the NCLAT has held that they must clear the dues as well. What's your take as far as Arcelor Mittal's position is concerned?
Yeah, I don't think they're a very happy house at the moment, I would have thought, because there's a lot of money to pay out, really only as an eligibility criteria for another bid process, which they may or may not win. So you're paying off $1 billion really to become eligible in a process which you may not eventually win. So I don't see how they can be happy with this at all.
Shroff, the NCLAT has given a few days to Arcelor Mittal to pay the dues and then make themselves eligible. Correct me if I'm wrong, but under the Insolvency and Bankruptcy Code, isn't the bidder required to complete dues at the time of submission of the resolution plan? And if that inference of mine is right, then do you think the NCLAT has been a little tad generous by granting time to Arcelor Mittal to pay these dues?
No, Ashwin, if you see the history of this particular case, there was an intervening judgment of the NCLT in Ahmedabad, and that had relied upon section 30, where they had held that it was an entitlement of both the parties to get a right of hearing, post-decisional hearing, and in circumstances they could make the revisions and effectively pay off whatever ineligibility if held against them. So there was an intervening judgment, and the NCLAT has effectively continued that observation, because clearly in the midst of the hearing, even before the appellate tribunal, the submissions made by Arcelor Mittal is that they have kept the funds aside in escrow, subject however to the condition that they are declared the eligible, the winning bidder. Now that winning bidder concept will have to go by or given up because of the decision of the appellate tribunal, and that is the differentiation. But both the original tribunal, that's the NCLT and the NCLAT, have held that because the question of eligibility was yet open, they will have time to cure the eligibility, notwithstanding the language of section 30.
Right. So the parties will have time to cure their ineligibility. Mr. Alok Dhir, this judgment puts Arcelor Mittal in quite a sticky situation, doesn't it? Because A, they have to pay $1 billion, and that's the rough amount, around 7,000 crore rupees of dues linked to Uttam Galwa and KSS Petron. and then they become eligible. Then they have to match the bid submitted by Numetal in the second round, which we are all aware and has been disclosed by Numetal is 37,000 crore rupees. Imagine being in a situation like this wherein you are paying dues, you're not too sure whether you'll win the race. So it's a tough commercial call for them at this stage, right, Mr. Dhir?
Yeah, I think we have to look at it from the perspective of it being a legal issue. 29A is there. It came on the statute book by ordinance on 23rd November. Clearly, it has been now held that Arcelor Mittal was not eligible on that date, but under the second proviso to section 30 subsection 4, they are granted that additional 30 days time within which they can purge themselves of the ineligibility. Now, if that is the legal process and that is available to everybody, I don't think Arcelor Mittal should be having any grievance that it is expected to comply with the provisions of law. In fact, according to me, an additional period of 3 days has been given to Arcelor Mittal only for the purpose that they may still comply, considering the fact that they have already put 7,000 crore in escrow account. Now, looking to it from a commercial standpoint, if they have to cure or purge themselves out of the ineligibility which is legally established against them, that's the money they have to pay, but the choice is entirely theirs. It is for them to pay this money, prove eligibility, and thereafter proceed to make a bid. And therefore, if they are still keen, they will have to comply with the law and the rules, and therefore they will have to pay this money before they can make a bid, which is a legitimate bid for the takeover of Essar Steel.
Conditional bid as far as the road ahead for Arcelor Mittal is concerned. Krishnava, I'm going to come to you and speak to you about the entire controversy or war of procedures to be followed vis-a-vis maximization of value. But before that, I want to dig Nilang's brains on what he feels as far as Numetal's current position is concerned. You know, they're placed in a very pretty position. Nilang, would you concur with that?
I think so. I think from their perspective, it's almost as good as they could have hoped, because the only better decision they could have hoped for is them being eligible and Arcelor Mittal being ineligible, which I don't think would have happened. So this is as good as it gets, I think, for them at the moment. Having not had a read of the judgment yet, so I suppose some devil lies in that detail. But off the face of it, it looks very good for them.
Right. Krishnava, what is the message from this judgment as far as the whole concept of maximization of value is concerned? Do you think the NCLAT has reiterated that at the end of the day, that's what really counts?
Well, it's constantly been reiterating that. You know, just before I go to the maximization, just adding to, I think what Alok was saying, I haven't read the judgment, so not sure that, you know, whether at all it's a grace for Arcelor with that 7,000 crores being paid in, and then what? I'm not sure. I haven't read the order yet. Is the COC directed to reopen an auction bidding process, or they just take in a 30,000 crore bid and a 37,000 crore bid and then decide which is higher and close there? If that is the case and there is no avenue for Arcelor to get into it, then what sense would it make for them to pay? Unless and until there's some clarity that the COCs are open to go in for some sort of an auction or a negotiation between the parties, then would make sense for Arcelor to pay. As far as the maximization, as you know, it's been happening everywhere in Bhushan Power, Binani, now this consistently. Of course, Binani is still pending, but consistently NCLAT has been very clear. The narrative which has been overwhelming and overarching is maximization cannot be taken away on the garb of process, and that's something once again which he's you know, there's 37,000 crores on the table, and says you know, the second structure does not have Revant Ruya or the Ruya family anywhere there, and he's gone through that at all.
Right. Mr. Shroff, how important do you think it is for there to be a clear message from the judiciary regarding the balance of opinion between following the procedures and paying due credence to maximization of value? As Krishnava was mentioning, that's been constantly reiterated by the judicial forums. Is that the same line of thinking that has emerged from overseas judicial forums as well when it comes to a regime like the Insolvency and Bankruptcy Code? Maximization of value trumps everything and is above everything else?
So let me make it clear firstly that this judgment, and I have read it from cover to cover, does not speak at all of maximization of value. There is not a word written in this judgment on the concept of maximization of value. It is basically dealing with validity of bids and the fact that Numetal revised its offer in the second round. That has been treated as a basis on which Arcelor Mittal can negotiate and contract with the lenders and enhance its bid, because the Arcelor Mittal did not submit a second bid which is opened. So and that's not coming out from the judgment at all. The fact that Numetal made a second bid on the basis of an opportunity which was given by the Committee of Creditors has opened an opportunity for Arcelor Mittal to raise its bid if negotiated with the lenders. And Krishnava is absolutely right that if their bid is static at 30,000, then there is no purpose served in making payment of 7,000 to Uttam Galva and KSS Petron, because they are not going to win Essar Steel on a 30,000 crore bid, assuming that is the bid, because I don't find the figures in the judgment of the NCLAT. So this is not about maximization of value. This judgment has only restricted itself on the qualification and the consideration of the bidders and what would happen if both are to be in the race and a competitive pressure involved between Numetal and Arcelor Mittal. So this has nothing to do with the general principles which the NCLAT has been talking about, and that is sharply in issue in the Binani Cements case, not so much an issue in the Essar Steel case.
So it may not have been discussed at length or mentioned specifically in the NCLAT order, but I'm sure, Mr. Shroff, it will be playing on the minds of the COC or the Committee of Creditors. Mr. Dhir, 270-day time frame. I'm given to understand from the fine print of the order that the period which was consumed during litigation, that's been taken away. So a rough back of the envelope calculation would mean that the COC is required to close this resolution process within the next 35 days. That's the rough time period which I think the COC has. Now the ball is in the court of the COC, because the route has been shown by the NCLAT. They have told the COC this bid is eligible. If this bid has to be eligible, it has to pay up dues. If you were in the COC's shoes, what would your strategy be going ahead?
Let me first mention that in para 125 of this order, the NCLT says that the COC will consider the resolution plans, and they use the word "and if so necessary may negotiate with the resolution applicants." So while it has not elaborately dealt with the question of whether there is whether the stakeholders' value should be enhanced or not, but leaving that sentence, that particular direction there, that the COC will negotiate with the resolution applicants, it leaves no doubt in my mind that this would be for the purpose of enhancement of stakeholder value. That's one issue that I wanted to comment. The second is they've excluded the period from 26th April 18 to 7th of September 2018 from the 270 days. So as there are calculations will be made of what is the exact number of dates available, but we all understand that the time frame now left with the COC is extremely short. During this period, since there is only 3 days which is available to Arcelor Mittal, within very short period of time, the COCs will be aware whether there are other eligible parties and what is the bids which have been given by the eligible parties. Give them a bit of time for negotiation, and there also they will have to keep very short timeline and say that if there is any negotiation and counter bidding by anybody, then it has to be done within a short time frame, and then they would select whoever is the highest bidder and go on and issue a letter of intent to them and proceed with the process under the IBC. So I believe that there is adequate time even at this stage, considering this particular stage at which the entire case is balanced, for the COC to be able to take a decision and to be able to identify the best and the highest bidder, the most appropriate bidder, and take their call and issue the letter of intent and proceed to file an application before the proceed to hold a COC to approve the resolution plan of such a bidder.
Well, you heard out Alok Dhir over there. He beautifully laid out the roadmap before the COC as far as the completion of this resolution process is concerned. Let's not forget also, Krishnava, that the COC also has to evaluate a third bidder. In that case, the third bidder was Vedanta. Anil Agarwal promoted Vedanta. And my question to you is, do you think the COC would be tempted to use the Swiss challenge method, which we have seen in a few live IBC cases, has been implemented?
So I haven't seen the bid process document. So most of the process documents would have a built-in flexibility of giving the ability to the creditors to really negotiate and in a sense within the framework deviate from the process if there is a better value. And I know we've spoken about the maximization, but the fact is that if there is a possible maximization, whether the COC would do it or would it therefore mean the risk of both from a COC and even an Arcelor that when they have to pay a 7,000 crores up without any certainty of what COC, would it at all open it up? And if it does open up at all, then why not a third player as well? Why is it only between Arcelor and Numetal, and why not a third player as well? And if that's the mandate which the COC wants to run with. But it's tricky because on one hand it might again see another series of litigation going up similar to some of the others that we are seeing. But getting a sense from the judicial narrative that we have been, the COC very well may choose to take that step and say that let's since we've got 35 days time and we might choose to open this up.
Krishnava spoke about opening the entire process up. Alok laid out the roadmap. There are whispers of maybe potentially the COC considering a third round of bids, but I personally feel that would be really risky because then that invites fresh faces, new faces, and as Krishnava was pointing out, that could also invite litigation. Mr. Shroff, what are the grounds on which you think Arcelor Mittal can appeal this judgment? We are not too sure what their strategy is as of now. Their official stance is that they are reviewing the order and they will take the next step in due course. So they have three options. Either they pay the dues and they go ahead with the NCLAT order, either they withdraw from the race, or they go whole hog and challenge this order at the Supreme Court. So if they do challenge this order, are there any strong grounds based on which they can challenge this order and get some relief from the Supreme Court?
There are certainly issues which, there are arguments both ways in relation to the question of eligibility. They have raised the consideration that the issue of whether they were eligible has to be decided on the base date on which the resolution plan was lodged. And the fact of the matter that they have argued is that they were not promoters at that date because they had sold the shares. So this is something which has to be still tested by the Supreme Court as to whether the question of the relation back of holding of shares, how far does it extend to? Does it extend beyond the date of lodgement of the resolution plan? That's a question which is not decided yet by the Supreme Court of India. So I suppose that is one strong ground on which the Arcelor Mittal will pitch to the Supreme Court. There may be many other grounds, which they argued before the NCLAT, and all those would also be reiterated in the Supreme Court. But this particular issue of what is up to what point of time you are liable to hold yourself as an eligible bidder by virtue of the fact that you had a past overdue. That's one question. And the second issue, which I think is again a critical issue, is whether is it the liabilities of that particular account for which you're bidding, or any account which is outstanding in relation to the eligibility. The question of whether a person is liable for all its uncured insolvent companies, or whether it is liable to cure only that which is for which it is bidding, is also a second serious question which will have to be looked at by the Supreme Court.
Important point that you make, Mr. Shroff. To what extent are you liable for curing yourself in terms of being eligible in a particular IBC case. Mr. Dhir, what are the key takeaways of this verdict today for two sets of stakeholders? One, the lenders, and two, suitors. There are several other COCs as well as suitors that are closely following the developments in the NCLAT case. As Mr. Shroff was pointing out, there are sufficient grounds for this order to be appealed. So this is not yet the end of the story. In all likelihood, it may land up at the top court of the land. But if you could briefly summarize the key takeaways for lenders and suitors from today's NCLAT verdict.
Yeah, sure. Before I do that, I just want to point one issue out. One of the very critical parts of the decision in this particular matter that the NCLAT has done is that they have determined that the date of the filing of the EOI is the first step in the filing of a resolution plan. And therefore, for the purpose of 29A read with the second proviso of section 30(4), they have said that this step of filing the EOI was prior to 23rd of November, and therefore Arcelor Mittal is eligible to get the benefit of 30 days under the second proviso to 30 subsection 4. Now that, according to me, is a huge, if I may say, benefit that has been given, and apparently the NCLAT has said that if we do not do this, then there will be no eligibility in so far as Arcelor Mittal is concerned at all, and therefore to accommodate that issue, they have taken the date of the filing of the expression of interest being prior to 23rd November as the date on which the first step of resolution plan has been given. So that's a very crucial decision, and I think it will have an impact on the lenders and suitors insofar as cases where resolution plans have been filed prior to 23rd November, though not very many of those may be left at this stage. Having said that, I think insofar as the lenders is concerned, it is a very big step forward. For them, the issue of 29A has been decided once for all now, and on the question of eligibility, certain decisions have been taken here with respect to what is the impact of transfer of shareholding prior to the date of prior to the date of filing the resolution plan, and whether the ineligibility under 29AC will happen on the date on which the 1 year period from the date of NPA is over, and whether merely by the transfer of shareholding somebody can avoid or purge itself of the obligation. So all these things have been clarified by the NCLAT. Insofar as the suitors are concerned, it will only, they should be very cautious now that they should be filing bids only if they are eligible under 29A. Otherwise, they will run the risk, as Arcelor Mittal has done this time round, of putting substantial amounts in escrow and being agreeable to deposit such large sums of money for the purpose of filing their bids or competing bids, to find at the end of it that even after depositing such a large sum of money, they may still not be able to succeed.
Absolutely. Mr. Dhir, I'll have to request you to hold on to your thoughts, sir. We are completely running out of time, but I do get your point that finally there is clarity from the NCLAT as far as the contours and scope and applicability of section 29A is concerned, and one hopes that this controversial section does not haunt any further IBC proceedings. The battle continues. Let's wait and watch to see what Arcelor Mittal does. For the timing though, it looks like it's advantage Numetal. On that note, I must thank all my guests, Shardul Shroff, Mr. Dhir. I must also thank Nilang Desai, and of course, Krishnava Dutt of Argus Partners. Gentlemen, thank you so much for helping us dissect this crucial order that came in today from the NCLAT.